Live again here. Hopefully I didn't hit a wrong button, but we went through the housekeeping items, and at any rate, we're going to dive into the program right now. So, first off, I want to say a couple other things. What I do is every work day, every business day, I get emails from across the country about these new cases. What I do is I poll them. I then kind of cull through them and try to find the cases that I think are both interesting, but also that can help give the basis to really get us thinking about situations. Ideally, I'm looking for a situation that could be applied in multiple different contexts because I think that is the most benefit to people. I'll say also that what I've started doing is posting these quizzes every Friday morning on LinkedIn just as a benefit to people to kind of keep you sharp as well, because I realize a quarterly webinar is a lot, but a simple LinkedIn post with just the quiz and answer every week it's a nice way to try to stay fresh. All right, enough rambling. I need to get started. So this first case comes out of Missouri, and even though it's out of Missouri, it definitely could apply probably in every state in the country. So it's a classic situation. It's a real estate foreclosure. The lender files the foreclosure, and the lender does an affidavit. Now, there's this language in here in the motion for summary judgment that says, this is from the loan officer, the person that signed it. I quote, "I have personal knowledge as to the acts herein based upon my review of the record and the loan documents." And then the affiant says, hey, a default's occurred, but he doesn't attach any supporting business records. Now, the trial court says, yep, I see it. There was a default that's occurred, but the borrower says, no, you didn't prove your case. You can't do it, and we're going to appeal it because it has inadmissible hearsay. And so the question is, when somebody has this statement that says, I have personal knowledge based upon my review of the record and the loan documents, but they don't attach supporting business records, have they carried the day? What do you think? We'll pause. All right, let's jump to the answer. Well, the borrower wins in this situation. And in this particular case, the appellate court became super fixated on the fact that the affiant didn't have any personal knowledge other than the review of the documents. And the other problem here is that there wasn't the fact that the business records weren't attached. Now, the question is, how could you have done something like this? The short answer is, well, in preparing the affidavit, what the lender should have done is included language that would satisfy the business records exception for hearsay, so that way there would be an evidentiary basis to get it in. And then, as you can see there in the middle bullet point, the key is attach the business records. And here I think this really goes to my bottom bullet point right here. A lot of times we know exactly what's going on because we're swimming in the waters, we can see it, and sometimes we fail to realize that somebody who hasn't been swimming in the waters might have a difficult time just immediately recognizing what's going on. And so I think a very good rule of thumb is that when you're in any type of these situations, if it's in some sort of litigation, you want to be putting forth not only kind of your narrative of the facts, but you want to put forth the underlying documents so that somebody looking at this, they just look at it and go, duh, the borrower's in default. They owe the money, right? You want them, it's like leading a horse to water. You're trying to bring them there, and you want to make it as easy as possible so that they can get it and get to that immediate conclusion. If you do that, then you're going to, satisfy these hearsay issues. But I think more importantly than that, at the end of the day, when you're in this litigation, you're trying to persuade somebody. And so the more credible documentation, the more easy to understand the story is that you put forward, the better off you are in, trying to dispose of your case pretty quickly. So, all right, let's jump to the next one. Tom?
Yeah, thanks, Mike. And hello, I'm Tom Donaldson, a partner in the St. Louis office. I'm not sure if we were cut off maybe at the very beginning there. Very warm in St. Louis today, and I was telling Mike that I decided to forego the suit jacket. It's very warm in our office, and I figured it's better to be a little less formal than to pass out in the middle of this thing. So bear with me here. So here's the next one, and we've got a little bit of a long fact pattern, but I'll read this and then we'll see what the result is. Following a default, a secured party initiates a non-judicial disposition of personal property collateral under Article 9. The debtor argues that the sale was not commercially reasonable. They had several arguments that there were no potential bidders or purchasers that could have examined the collateral. A secured party refused to provide the debtor with information regarding marketing, how the sale would be conducted, or information that the secured party had sent out to any potential bidders, and that the sale of the personal property, in this case there's real estate, the sale of that separate from the real estate collateral would result in ultimately less value. The secured party contended that the debtor actually waived its right to receive a commercially reasonable sale because they had entered into a forbearance agreement that suggested that that right was waived. So who wins here? Answer is the debtor. So the right to a commercially reasonable sale is not something that can be waived by a debtor. And if commercial reasonableness is raised in connection with a non-judicial sale, it falls on the secured party then to prove that it was in fact commercially reasonable. Some takeaways here. Obviously commercial reasonableness is vague and it's a non-judicial sale. So, they have to be, secured parties have to be very careful when they're conducting non-judicial sales of personal property and take into account, all the factors, including what the collateral is, where it's located, and, the marketplace of buyers available. Just a couple of reminders. So, most of the time when there's a non-judicial sale under the UCC, if the secured party wants to end up being the buyer of that property, they can't really sell it to themselves in a private sale. Some sort of public sale has to be conducted, obviously to maximize value for everybody. Strict foreclosure, this is, goes way back in the day, not really a thing anymore. And it is available under UCC Article 9, but it basically requires the cooperation of the parties. Court oversight is sometimes nice. It kind of takes you out of that uncertainty of being in a non-judicial process. And appointment of receiver is certainly one of the remedies we often see pursued in situations like this. And I'll turn it over to Joe.
Thanks, Tom. My name is Joe Price, and I'm a senior associate in our Omaha office. So happy to be here presenting today. The third question comes out of a case from the Southern District of Mississippi. And here the debtor obtained 4 separate loans from the same credit union, 3 of which were purchase money security interests. They were loans obtained to buy the thing that then secured the loan. And the 4th loan was an unsecured loan. So the question is, do cross-collateralization and future advanced provisions in a loan or security agreement change a PMSI security interest into a standard security interest? And the issue was the debtor tried to claim that by including cross-collateralization provisions in the 4 different loans, it defeated the lender's ability to take the collateral from all 4 loans and apply the proceeds of that across the 4 loans for payoff. And the answer the court reached was no. The inclusion of cross-collateralization and future advanced provisions in a loan would not change the PMSI into non-PMSI. The lender who was secured from the collateral on one loan was allowed to apply the equity from that collateral towards the repayment of the unsecured loan. So kind of the reason why the court reached this was PMSI is a security interest taken in goods securing a loan for which the purchase is made for those same goods. And they felt that just by cross-collateralization, which is a very common feature in loan and security agreements, that didn't necessarily change that outcome. One important note that I wanted to make here is that a subsequent loan, so if a debtor got a loan to buy a car, and that security interest would be PMSI if the loan is then secured by the vehicle that the debtor purchased. If the debtor then were to go and refinance that loan subsequently to pay off the PMSI loan, that secondary loan would not be PMSI if it's not secured by the same vehicle. So I think that was an important distinction here to make. Mike, I'll turn it over to you.
All right, I gotta add just a couple commentary there on Joe's item. The PMSI, intuitively, what the court there did made a lot of sense, right? Because if you've done a PMSI loan, I'm just making up numbers here. Maybe the collateral's worth $100,000, the loan's worth $75,000, so you have $25,000 equity. Well, you advance the money to enable the debtor to get that piece of collateral in the first place, which is how you get that. And so the court's essentially saying, hey, you have this PMSI priority. We're going to allow this cross-collateralization to come in. So it's neat to see that the court's recognizing or kind of solidifying the PMSI. We actually had a PMSI one, and I think it was the last quarter or 2 quarters ago. The issue was, well, what if you didn't properly, get your PMSI within 20 days? Does that nix your security agreement? And the answer is no, it's still valid. PMSI just goes to priority. But so anyway, it's good to see the courts doing that. All right, so we're going to jump now into bankruptcy real quick. This case comes out of, we're moving from one southern state, Mississippi, over to another one, South Carolina. So this is one, comes in chapter 13, but there's important principles here. Don't dismiss this because this is 13. The principles here we're going to talk about could definitely apply in a 12 or a chapter 11 as well. So in this particular situation, the lender has a lien in a shed. Debtor files for chapter 13, values the shed at only $200, and then files a plan saying, hey, I'm poor. I'm only going to be able to pay $5 a month. So the lender doesn't object. I think the original loan on this shed, it was small. It's like $5,000 or $6,000. Somewhere in that vicinity. So the lender doesn't object to the plan, but another party objects. So then the debtor files a modified plan. The lender says, hey, I don't like what's going on here. I'm going to object to the plan, this modified plan, saying, hey, this treatment that you're doing for me and my lien is improper. And so the question is, who prevails here, the lender or the debtor? All right, well, the answer is the lender, kind of, but it's a split decision. And in a way, the lender loses here too, right? So the court says under this section 1323C, the lender is deemed to have accepted the modified plan because the treatment under the modified plan was the same as the original plan, all right? But the court comes in and says, debtor, you're just doing this in bad faith. This property was, $5,000 or $6,000. You can't just value it at $200 and then pay a pittance to the lender. And so the court comes in and ultimately hits the debtor there. Now, what do we learn from this? Well, I've said this in prior webcasts. I'll say it again. There's a principle that applies in weddings and in bankruptcies, and that is speak now or forever hold your peace, all right? That is an important principle when you get into plan confirmation. And you see these modified plans in the Chapter 13 context, definitely in the Chapter 12 context. You could even see it in the Subchapter 5 context where they confirm the plan, they're humming along, and then, of course, the economics change, and then they want to modify the plan for whatever reason. And the point here is that if you are not objecting originally, you're probably going to be stuck with it, even if it's bad in the first place. So again, that principle, speak now or forever hold your peace, you need to remember that when you're getting into plan confirmation. The other point here to keep in mind is, the court came in, the court did its job in this situation, and they could see that the debtor was playing games here, and the court didn't like it. So kudos to the judge in that case. My warning is, most of the time, judges are not that involved. The Chapter 7 trustee or U.S. trustee, they typically are not that involved. Occasionally they'll interject themselves, but don't plan on the court or some third party trying to carry the day for you. You need to put it on your shoulders and move forward with your objection. All right, Tom.
Yeah, thanks, Mike. A good question came in on my last case, and I just want to address that real quick. So the question is, remember my case was about commercial reasonableness and an Article 9 sale. To what extent can the parties contract to establish standards for what will constitute commercial reasonableness? And of course, what I think about there is just about every security agreement I've read and perhaps written. My guess is, without looking, this is probably in Laser Pro. There's a statement that 10 days is a commercially reasonable amount of time. And would that be upheld? I think it depends on the collateral. I would, if you're in a contentious situation and the collateral is a type that it really cannot be sold in the marketplace, and yield what you would expect it to. All things considered, everyone knows it's a liquidation, but if 10 days isn't enough, then I would give more than 10 days. But look, I'm an attorney. I'm nervous about these things, and I want to be especially cautious if the process is non-judicial. Mike, I don't know if you have any thoughts about that.
Yeah, I do. A couple thoughts on it. It's a great question, and you're spot on, Tom, when you say it depends on the collateral. I'll give you an example. Like if you're dealing with machinery, farm equipment, just something where there's a recognized market that's out there. 10 days is, that's what the code says, and there's well-established markets. So I feel pretty good about that. But the flip side is when you get into something specialized like intellectual property, maybe you have a patent or something. I'm from my own personal experience, from what I know of patents, 10 days is just not enough time to really appropriately market a patent if you're going to try to take it to sale. So, I mean, yeah, do you want to have something in your loan documents? Sure. I mean, there's draft it in there, put it in there. You have the parties agree to it. And so at a minimum, you can argue to the court that, hey, you had a meeting of the minds. Everybody said this is commercially reasonable. But at the same time, you need to kind of step back and say, okay, now just ignoring for a moment the language in the agreement, is it objectively reasonable? And candidly, you want to have kind of an intersection to where you have the parties agreeing on what's reasonable and then stepping back, what is objectively reasonable. And admittedly, it's like you've got these two spheres that intersect at one point, and the question is, there will never be maybe a complete overlap, but you want to have enough of an intersection so that you have a colorable argument that from an objective perspective it is reasonable. I know that's not a super good answer, but it's kind of the best principle we can illustrate in this situation, which is it depends on your collateral and it depends on the market that you're dealing with. And then admittedly, when you're thinking through this, you can say, oh, well, I could have a situation where we could liquidate the equipment through an equipment auctioneer in relatively short order. But then the more specialized items, such as the patents, we're going to maybe need to take a bigger perspective. If you can sell them separately, great. But sometimes, the fact that it's more like a going concern with the equipment coupled with the patents may actually make it more valuable. Then you're in this dilemma of how we're going to maximize the sale. So anyway, Tom, I'm rambling. I'm chewing up precious time here, so I better hush up and let you move on to number 5.
Thank you, and thanks for the question. And this is a pretty straightforward one, so we don't need to spend too much time on it. A secured party has a security interest in a deposit account. The debtor transferred funds out of the account to an innocent or non-colluding third party. in other words, they weren't trying to conduct, basically fraud. Can the secured party succeed on a conversion claim and claw back the funds from the recipient? The answer is no. And so this is not 9332 under the UCC. A transferee of money can take the money free of a security interest unless the transferee acts in collusion with the debtor, violating the rights of the secured party. And there's just a reminder that public policy is generally going to favor innocent recipients of funds over the rights of secured lenders. If you're a secured party, obviously not a great result. So what can you do about it? I go back to the loan documents, and if there's concern about controlling cash, consider implementing tighter controls over the cash. Perhaps putting a control agreement in place, or in the pledge agreement having restrictions on when those funds can be withdrawn.
And Tom, I want to interject. I can't help myself.
Sure.
The one key thing, and I know on these webinars, this is something I've said repeatedly. I'm just going to preach it again. You want to make sure that you are perfected at each step along the way. It's like, Einstein riding a light beam, right? You want to jump on your collateral and go through the process, and it may be inventory, it may be work in progress. Now it suddenly becomes AR. Now that AR is turned into cash. And the question is, at each step along the way, am I perfected? And do I have the ability to get my hands on it? And that sometimes is where lenders run into trouble, because they think they've got a blanket broad approach, but then something's happening to where there's a weak link. An example is maybe they get AR that's out there, but it's not being put into a lockbox account. And so what happens then is the borrower then diverts that AR, that cash coming into maybe a different institution where there's no deposit account control agreement. So that's when you run into problems. So admittedly, you can't always get that perfect perfection and control along the way, but it's good to have that mindset to try to protect yourself. All right, I better hush up. I can't help but make the commentary. All right, Joe.
All right. So the background on this case, an entity with some special purpose subsidiaries owned several parcels of real estate, and they obtained a loan in the amount of $6,575,000, which was secured by the various parcels of real estate that was owned by this group of entities. The borrower defaulted on the loan, and the parties entered into a consent judgment, which provided for adjusted terms of repayment, and as well as giving the lender the right to take repossession of the property. The borrower then again defaulted on the terms of the consent judgment, sold the property for $5 million through CBRE, and then filed a motion for deficiency judgment against the entities and the guarantors in the amount of $5.2 million. Now, the borrower group argued that the deficiency judgment could not be entered because the sale was not conducted in a commercially reasonable manner as was required by the UCC. And as evidence, the borrowers pointed to the fact that they obtained an appraisal that valued the property at nearly $8 million instead of the $5.25 million that the property was sold. So the question is, does a lender need to meet the commercially reasonable standard under the UCC when foreclosing on real estate? And the answer is no. The court looked at the collateral, and it was real estate collateral as opposed to general goods, which meant the UCC did not control. Instead, the consent judgment is what controlled the terms of the sale. So some key takeaways here. The UCC would not apply if real estate is the collateral. And the controlling document then, instead of the UCC, is the agreement between the parties. So in that instance, the parties, kind of in line with what Tom and Mike were talking about, setting what would be commercially reasonable, can get together and contract for what would be commercially reasonable. And what that would look like definitely depends on the type of property, what kind of market is out there for the property, that sort of thing. But it would be a good idea for a forward-looking lender to sit down and set those terms for what is commercially reasonable. And then if the loan goes sideways and you end up foreclosing and having to sell the collateral, as long as you're following the steps that is set out by that contract, then you'll most likely be protected from the borrower or debtor then coming back to try and attack that sale on the back end. Mike?
All right. That last one was in Michigan. We're going to stay in Michigan. Now, just because you may not do ag lending, you see Chapter 12. Don't zone out on this one. This is a back to basics question. All right. So, simple situation. The borrower's up there in Michigan and they've got a farming operation. They filed Chapter 12. The lender has a lien on the real estate. There's a default. This is kind of a classic situation, right? The lender files the foreclosure action. The sale's scheduled for May 23rd, but guess what? The borrower says, nope, not going to let that happen. We're going to file for bankruptcy a couple days before to stop the foreclosure sale. So the lender obviously is upset about that, moves for relief from the automatic stay. And the question for you is, what must be shown for the lender to obtain relief from the automatic stay? I'll pause, let you think about this. Keep in mind, these stay relief requirements, they're applicable in whatever chapters, 7, 12, 11, or 13. All right, well, here's the answer. There's a couple of key elements. You have to have the showing that A, the debtor has no equity in the property, and B, the property is not necessary to an effective reorganization. All right, so then the question is, who has the burden of proof? Well, Part A, showing that the debtor has no equity in the property, that's your burden. That's the lender's burden. And that's pretty simple to show, right? You say the debt is worth, $1 million. The property is only worth $800,000. There's no equity in the property. Now, the flip side, the downside to all of this is that if there is equity, then you can get interest in the bankruptcy proceeding in Chapter 11, Chapter 13, or Chapter 12. But if there is no equity, you're not going to be entitled to get interest on your debt. It's just the way the bankruptcy code is structured. So you get that prong. Does the debtor have equity? But then the next question is it necessary to an effective reorganization? Now, the question there is, as the court pointed out here, the debtor bears that burden, and the debtor has to show that it can effectively reorganize, right? It's not just a reorganization, right? Anybody can reorganize and have the plan fail miserably in 2 months from confirmation. The question is the confirmation likely to succeed? And so then you get into this really unique situation. It's not like when you're getting a TRO, a preliminary injunction, or something like that, but a lot of times in those situations, you essentially end up having a mini trial on the underlying merits of the case itself. That scenario, that potentiality arises here in a Chapter 12 case, because if you can show that there is no equity in the property, the question is this property necessary for an effective reorganization? That's a difficult question. And so then the debtor is going to get in there and say, oh, I need it to, do this or that. And obviously in this case, if it's the farm, clearly the debtor needs the farm to, plant the row crops or whatnot. And then the question is, well, can the debtor cash flow? And now suddenly you get back into all that financial reporting that the debtor should have been doing, that hopefully you have collected, is actually pretty important, because you can point to historically this debtor hasn't been able to do it. The debtor doesn't have a chance to reorganize. In this particular case, the stay relief was granted. And so kind of the takeaway here is that if you feel like you're going to move for stay relief, you need to be prepared for what I call this mini battle. But then you got to have kind of a reality check, which is if there's equity in the property, or if the debtor is going to get up there and say, hey, I really need this to reorganize, the court may go against you. And here's the hard reality. Particularly when you're at the beginning of a case, when you move for stay relief, it almost feels like a lot of times bankruptcy judges want to give debtors the benefit of the doubt. So yes, you can move for stay relief. Unfortunately, you don't always get it. You're not hurt by doing it, other than you're out the attorney's fees and the effort for it. But you want to keep these principles in mind. All right, Tom, better move on here.
Great. Thanks, Mike. This is a case out of Utah. And pretty straightforward case. So you've got an equipment lease that has a security agreement or an embedded security interest grant contained within it that the debtors, all right, I suppose lessees, were granting a security interest to the lessor in, quote, all assets to secure their obligations under the lease. The debtors later argue that that grant of the security interest in the lease was ineffective because it did not reasonably identify the collateral. Who wins? The debtors win in this case. So the court concluded that the super generic description, all assets, did not reasonably identify the collateral, and therefore it was ineffective to grant a security interest in the assets of the debtors. So, remember, you've got two things here. You've got creation and perfection, right? I was talking to Mike before we went live about my gray hair, and we were debating whether it was just the natural process of aging or teenage kids, which we both have. In any event, I've been around for a while. And I was actually around in 2001 when there was a major overhaul to the UCC that was put in place. And as part of that overhaul was you can file a UCC financing statement that just says all assets or all personal property. And that is effective from a filing by perfection standpoint to perfect the security interest that was created in the security agreement between the parties. However, that doesn't mean that the security agreement can say all assets. The security agreement still needs to have either a listing of the collateral covered by the terms that we all know and love in UCC Article 9, goods, inventory, et cetera, or perhaps specific description if you've got a piece of equipment with a serial number and all that good stuff. I think some interesting practices kind of developed or stemmed from that UCC overhaul, which, by the way, for the younger people, I believe it was a piece of carbon paper we had. It was small, it was perforated, and there were different pieces that you tore off and you filed with counties and that sort of thing. So we've come a long way with the central filing system. Anyway, enough old guy talk. One thing I think is interesting here is how partial releases have been dealt with the super generic or all assets security or collateral description in a UCC filing. What do I mean by that? Well, let's say you've got an all assets filing out there, and the secured party needs to release one specific piece of equipment. Is the right place to effectuate that release a UCC filing or a separate document, a release that is not recorded or filed? My suggestion would be, remember, going back to creation versus perfection, if your security interest is created by an agreement between the parties, I would think also that the release of the security interest would be an agreement between the parties. And so I thought it was interesting that, and I've sort of watched this happen over the years, where partial releases get effectuated by filing UCC 3 with the deletion of collateral box checked, and that specific equipment being described in the deleted collateral. Does that remove the security interest? I would say no, it doesn't. It just, because remember, your UCC is all about perfection, not creation. Why do we do it? I think it's like a feel-good sort of thing especially for the parties that might be interested in seeing that lien removed. There's some evidence in the public record of it, but in my view, what you really need and probably only need is a release of that security interest from the secured party. Um, I don't know if you have any thoughts on that, Mike. That's a little bit of a tangent, so I appreciate you all letting me get on my academic soapbox.
Yeah, no, it's a great tangent. Yeah, I'm thinking back. I remember when Article 1 was amended, and I'm like, man, that's a long time ago, right? But Tom raises a really good point, and let me add a little bit of a tangible example to think about. Imagine your borrower is in need of cash. You've got a blanket lien on assets. You're done dealing with the borrower in the sense of you're not going to advance any more cash or no more line of credit, no more credit card use. And so they're desperate for cash, and so they want to go out to a factoring company. All right, always red flag when your borrowers run into a factoring company to get cash, but let's just assume those facts for a moment. If you're in that situation and you have an all assets filing, the factoring company is going to want to get at least a UCC modification showing that you've released the lien in the AR. But Tom makes a good point. That only goes to perfection and priority. You actually still have a lien in the AR, unless you delete it out of the security agreement. So you may want to get in there. You may need to tinker or do an amendment to the security agreement, or it may be that the factoring company doesn't care, doesn't wake up, doesn't realize about it, and they may be content with the UCC. But you keep in mind, because you're brighter, right? You know what's going on. You realize you actually still have a lien, and you could actually become re-perfected by filing again a UCC financing statement. Admittedly, you may be subordinate to that factoring company. So anyway, it's interesting when you move these chess pieces around in different scenarios. It helps you think about it. Yeah. All right, Joe, I think we need to pick up the pace a little bit. We only have 20 more minutes, and we got to grind through 7 of these.
All right, I'll speed through. So this case was a class action in Missouri, but the court focused on one kind of specific instance in determining the outcome. So the borrower took out a loan for $15,000 from GM Financial to purchase a vehicle using the proceeds of the loan. The borrower then defaulted on the loan, and the lender sent a notice that the vehicle would be sold via private sale 10 days from the date of the notice. The lender then sold the vehicle and sent a deficiency to the borrower in the amount of $8,000. The borrower argued that the lender could not collect on the deficiency because the lender violated the UCC by not providing a specific date and time of the place of sale for the vehicle. So the question was, is a notice of private sale properly given if the notice does not include the specific time and place of the sale? And the answer is yes, the notice is properly given, because in a private sale context, and I'll emphasize private sale, the notice is only required to provide the date or the time after which the sale is to be made. So the notice saying that the collateral will be sold 10 days following the date was proper. Now, if it's a public sale, so a notice of a public sale, at that time, the notice would then require the date and time of the sale to be valid under the UCC. And the reason for that is, in theory, it then allows the debtor the opportunity to show up to the sale and bid to get the collateral back. So our key takeaways on this one, it's very important to strictly comply with statutory notice requirements. In this case, had the court found that the sale was not properly conducted, then the lender would have been barred from obtaining a deficiency judgment, which is not a favorable outcome at all. If, on the other hand, you do in a consumer transaction follow the strict requirements of the UCC, you can go ahead and seek to obtain a deficiency judgment to cover the difference between what the collateral was sold for and what the debtor owed on the loan. And then the final point is, if ever unsure of what the requirements are or how kind of to proceed with a UCC sale, go ahead and seek legal advice to make sure that you're following what you need to. Mike?
All right. Interesting case here. Comes out of the great state of Washington. Typical scenario, you have a lender with a lien in the borrower's assets. There's a default. Lender is going to issue an account turnover notice, but guess what? Once all those notices go out, that just sends jitters through all these people that the borrower is dealing with that, which causes the borrower ultimately to default on its projects on which it's working. Borrower is livid, very upset. Lender, it's your fault I went out of business, right? It's your fault that I lost all these jobs. And so the borrower argues that the lender is liable for tortious interference with business or with these contracts because of the actions that the lender took, right? Now, let's just back it up. The lender, there was a default under the loan agreement. Lender has a lien in AR. Lender sends out the account turnover notices. You get the domino effect. The question is, in that scenario, is the lender liable for tortious interference with these contracts? What do you think? Well, the answer is no. And the reason is because the lender was, within the four corners of the contract and the law, right? There was a default. They issued the account turnover notices. And I mean, the reality of the matter is when you owe money to one of your creditors and those creditors come collecting it, has a negative domino effect, which typically has negative results for the debtor, right? When you're living in a house of cards and then one of those cards is pulled out and it comes collapsing down, it's kind of your fault for living in a house of cards in the first place. And so the court rules here in favor of the lender because the lender was doing what's right. Now, a couple of points here to keep in mind. If the lender is acting appropriately here within the scenario that we described, you're going to be typically safe from any of these tortious interference claims. Now, the one area I will caution, this is what I've seen. It was, I don't know, it was right around, I guess it was maybe a year or two before COVID when it hit. But what you will see occasionally is you'll get these private lenders, and they will have a provision in their loan agreement that says you can't borrow money from anybody else. Okay. But then when they file their UCC financing statement, they not only say we have a lien in all assets, they will also say our security agreement has a provision that prohibits the borrower from borrowing any money from anybody else. And in the particular instance I saw, the language was, and if you loan money to this borrower, you are tortiously interfering with our contract. I mean, that's pretty strong language to have something like that. It's certainly not very common, but it is out there occasionally. There are some private lenders that do that. If that's the situation that you're dealing with, and maybe it might be PMSI financing, right? It may be something where you're adding a new lien. The concern or question that you have is, by me entering into this agreement, am I suddenly opening myself up to a tortious interference claim? And my word of caution here is, if you're seeing something in the UCCs, if there's something that's outward that says this borrower is under a contractual prohibition that prohibits him or her or it from borrowing money, then you've got to think and be a little bit more concerned about the tortious interference claim in the future when everything kind of goes down the toilet and things aren't working out well. Again, this goes to good underwriting standards, good practice there, identifying these issues. Now, it may not be in the UCC. Again, but you want to look at the loan documents, and if you have concerns about this, it's good practice to take a good hard look at it. All right, Tom?
Great, thanks, Mike. So the question here is, this relates to a guarantee. A company shareholder executed a continuing guarantee in favor of a lender, guaranteed the obligations of that company. Then the company and the lender later extended the deadline for payment by an additional 4 months. Of course, that resulted in additional interest accrual. The guarantor in this case argued that that modification of the debt was a material alteration of what the guarantor's obligations were under that guarantee, and that the guarantor's liability should be discharged because the guarantor did not consent to the modification. Who wins? Okay, in this case, the lender. So this was a situation with a pretty clear and unambiguous guarantee agreement that covered future liabilities. You can see this case was out of Missouri. Before I go to the next slide, I will say it was kind of nice reading this case. And so for anyone who likes to read cases, or which, granted, may not be a lot of you. This particular one I thought was a good review of Missouri law on guarantees and what types of defenses could be raised and that sort of thing. So feel free to take note of this case if you want to take a look at it for a refresher. All right, couple quick takeaways. So lenders could consider getting a consent and reaffirmation of the guarantee, just to be kind of get ahead of any potential defense here that somehow the obligation was modified and the guarantor didn't consent to it. I realize that's not something that can be obtained every time. In my practice, and if I've got any clients in the audience, you know that I like this practice generally, to have guarantees reaffirmed when there's changes being made. And just a reminder that continuing guarantees in general can be terminated by the guarantor as to future obligations. Of course, whatever's been outstanding and still is outstanding at the time of the termination is given, or the notice is given, that still remains. But guarantors generally have the ability to terminate as to future obligations. And this last point I mentioned previously.
And Tom, I can't help myself. I just got to interject. I want to just say a big amen to what Tom said about, I think it's a good best practice that if you're doing a refinancing or doing something new, you get this reaffirmation, consent. Maybe they execute the same boilerplate guarantee language again. But what that does is it nips in the bud any argument that the guarantor may say that there's been this major substantive modification of the debt, therefore I'm not liable. I think I've been in the trenches litigating this issue, and I just want to say to Tom, that's like a really good best practice from a lender's perspective to avoid all the money that a lender may deal with when a guarantor is raising those defenses, trying to get out of the obligation. Joe?
All right. So in this case, borrower and lender entered into a floor-plan financing agreement. And as security for the agreement, the borrower granted a lien in all current and after acquired inventory. And the lender filed a UCC-1 on that. And I want to pause here to note, vehicles and trailers, liens to be perfected generally need to be noted on title. But here, since the debtor was holding the items as inventory, the UCC-1 filing was proper to perfect the lien in that inventory. Now, while the floor plan was outstanding, the borrower transferred 10 trailers to one of its affiliates without any release of lien by the lender. After the transfer, the borrower's affiliate then went out and got a new loan secured by those same 10 trailers that were transferred. And the facts of the case were such that the new lender probably should have known that the borrower and the affiliate were affiliated. The signatories were the same. They used the same letterhead. There were a lot of clues there that should include the lender and the fact that they were affiliated. The new lender then filed an action after things went sideways to determine who had the superior security interest in the trailers. The new lender argued that the lien was extinguished because the affiliate was a buyer in the ordinary course. And since the affiliate did not hold the trailers as inventory, the new lender was perfected because they had noted its lien on title. The question was, did the transfer of collateral between the affiliated entities extinguish the initial secured party's perfected lien? And the answer was no. The security interest continued notwithstanding the sale or other disposition, unless the secured party authorizes a disposition free and clear of the security interest, or the second option is the debtor makes a sale in the ordinary course of the debtor's business. So the general rule here is that the security party will retain its interest after transfer unless the sale is in the ordinary course or the lender authorizes and releases the security interest. Now, a buyer in the ordinary course, the court defined as a person who buys something in good faith without knowledge that the sale violates the rights of another person. Now, because the same warm-blooded individual controlled the borrower and the affiliate then had knowledge that the sale violated the rights of the lender, and therefore the affiliate could not be the buyer in the ordinary course. Additionally, the court went on to say, given the facts and the intertwined nature of the two entities, the new lender should have went out and run a search on the affiliate, a UCC search, and that would have revealed the security interest of the lender, which would have kind of avoided the whole situation. So the key takeaways here, if you're in doubt, it's quick and easy to run a UCC search on the original owner of the collateral that you're looking to take a lien on. The court placed the burden on the third-party purchaser to determine whether a security interest exists on that collateral. And businesses purchasing inventory from affiliates under common control will have a hard time proving that they're a buyer in the ordinary course. Mike?
Yeah, gives you a lot to think about when you are in a refinancing context, right? And you're loaning into a situation. Are you taking it clear? So good stuff. All right, I know we need to pick up the pace because we only have 7 minutes and we're supposed to get through 4 of these. This is an intriguing case out of New York. I love forbearance agreements. I think they're one of a lender's best tools when you get into a workout type of situation. But this gets to the issue of, can you void a forbearance agreement? Ooh, right? Just sends shudders down my spine thinking about that one. What happened here is they entered into a forbearance agreement, but it's the borrower, guarantor, and then there were some affiliates that were parties to that forbearance agreement who were not parties to the loan agreement. The borrower files for bankruptcy, and then they come in and they make various arguments, but the point we're focusing on here is, could the agreement be voided on the grounds of economic duress? Basically, you're the big bank, you made me do it, right? I can avoid it. That was essentially the argument, right? So what's the argument? Can they void on economic duress? The answer is no, you can't. And the reason gets into right here, to be voidable under economic duress, you have to deprive the borrower of its free will, right? And just because you have more leverage, that's different than depriving a party of free will. There's a distinct difference between those two. Now, we don't have time to get into the weeds and the muck of it right here, but there is a big warning that I'm going to flash out there, which is, if you're getting into a forbearance agreement, you might potentially, depending on how the debt's structured, be opening yourself up for a preferential transfer or constructively fraudulent conveyance. And that is particularly true if you're bringing in somebody that was never a party to the original loan agreement. So I've got like a whole hour-long presentation that would make a lot of sense, but we don't have the time for it, and you don't want me to run over. So we're going to move on to the next one, Tom.
Thanks, Mike. And I can do this one pretty quickly as well. So a lot of us have seen this structure of a bank, what we call a bankruptcy remote company, and it's set up on the front end in a commercial loan transaction. And there was a recent case in Illinois which upheld this structure. And the basics of it are this: typically the borrower is a Delaware limited liability company. It enters into a loan agreement with the lender that requires the appointment of an independent manager. The LLC is manager managed, and in the LLC agreement or operating agreement, it provides that that independent manager has to approve a bankruptcy filing. And this is something that we've all seen, has been around for a while. It's a recent case in Illinois that upheld it. Joe?
All right. So this case involved an ag company that had long-term agreements in place with 2 different dairies where they sold and paid off ag products, inputs, that sort of thing. The dairies went under a, quote, refinancing endeavor with a capital advisor group, after which the advisory group took control of the dairies and said, you need to stop paying this ag producer. The ag producer then turned around and filed actions for breach of contract against the dairies for failure to pay invoices, and then an action against the capital advisor for tortious interference with a contractual or business relationship. So the question was, does the lender's takeover and direction to the debtor to stop paying invoices create an action for that? And the answer is potentially. So this case was very early in the procedural process, but essentially the court left out the opportunity that the lender could be held liable in the event that it was not able to show some sort of justification for causing the debtor to stop making the invoice payments. Now the bar there may not be very high. The defendant could present facts that under the contractual relationship between the borrowers, it helped improve its position and ability to get repaid on the loan. But we included this just to call the attention that it's important to keep records about how these things are being conducted and be able to prove justification for making certain decisions when in a distressed situation. Mike?
Yeah, and I can't say how many times I've heard the situation like, oh, that's our collateral. They shouldn't be paying somebody that's unsecured, right? And I get it from a secured lender's perspective, but it's like, how much control are you exercising? You then, put yourself out there. Again, in this case, a tortious interference claim from this third party that was getting cut off. All right, we have just literally 1-2 minutes. We're going to do this one super fast. This deals with force-placed insurance. The gist of it is the debtor didn't have insurance. The lender goes out and gets force-placed insurance on the property, but the property, I don't know what the value is. We'll just say it was $200,000, but they get coverage up to $800,000. They then seek reimbursement of the force-placed insurance, and the court says it's not reasonable, right? Because the most the insurance company would ever pay out would be replacement value, which I'm making up the numbers here, $200,000 as opposed to $800,000. So what are the takeaways here? I get it that force-placed insurance is expensive, but the key thing here is we need to differentiate between the coverage amount. The carrier is only going to give coverage up to the value of the collateral versus the premium, right? And admittedly, the premiums for force-placed insurance are going to be more expensive than just kind of a private market. You're going to be okay if you can demonstrate, hey, that was the only thing available. I had to go with force-placed. But where you're going to run into troubles, where this lender ran into trouble, is getting coverage that was 4 times the amount of the collateral, because no carrier would have ever paid that out. So we are actually at the end of our matter. We've got a few key takeaways right here. We'll leave those. Those are in the notes that you can read and look at. Just by way of closing, what I do is I've started posting these once a week, every Friday morning for LinkedIn. You can look at it there. We're going to have our next quarterly webinar on June 25th. Again, we want to remind you that the program has been accredited or approved for legal education hours as well by the American Bankers Association, 1.25 CRCM and CERP credit hours as well. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for your watching and sharing. And then finally, we would appreciate if you would take a moment and just fill out the survey here at the very end. We really appreciate the feedback and the guidance that you can give us to help us to try to improve and bring helpful content that's truly helpful for you. So with that, on behalf of Joe and Tom, I want to thank you for being here with us today, and that will conclude our webinar. Thank you very much.